schedule has been announced in the month of June, and I have been conducting certain important lectures regarding the 4 papers, that is leading cases, ethics, drafting, Supreme Court practice and procedure for the last 5 years. Earlier it was in my chambers and in Indian Law Institute and other places. Now I thought since there is a technological advancement nowadays, I can upload my lectures in the YouTube and you can easily access it. This is a test upload. It will be followed by 45 minutes lecture on every subject, which I will be doing it in a short time. And by way of the YouTube, I will be announcing my direct classes also. But since I have already given my lectures in the YouTube, in the future, I think in the next week or so, all the 4 lectures will be given in the YouTube. And my direct classes will be on the basis of question paper solving. I won't be conducting classes. I will be announcing a particular question paper that every person would like to come and attend would have to solve and come. And I will be merely evaluating the strength and weaknesses of the candidate on the basis of the answers he is provided. Why? There is no proper lecturing procedure and question solving and evaluation procedure. Why this is done? This is also the most important point any AR examination aspirant has to take care. That is, see, in the AOR examination, what is expected from you? The AOR examination expects the candidate to be of a particular standard. That is, he must have enough knowledge of the Supreme Court practice and procedure, the way the matters are dealt with, and his analytical and spot-on approach to Supreme Court practice. This is what they try to evaluate. Whether a person in the shoes of an advocate on record would be able to carry himself as per the Supreme Court procedure and practice rules 2013, and whether he can address the filing requirements. You must understand that practice can be done by an advocate as per section 30 of the Advocates Act. However, acting as opposed to practice can be done by the advocate on record. So what the examination actually wants to know from you, wants to see from you before making you a pass is whether you are confident of implementing the practice requirements before the Supreme Court on your day-to-day practice. Filing, drafting, and several applications, interim applications, mentioning, and review applications, then curative petitions, then writ, then transfer petitions. All these are different areas of practice which are also on the basis of constitutional principles and Supreme Court rules. Whether you are able to collectively address these things and approach the Supreme Court. So this is what the Supreme Court would like to know from you before they can make you a designated advocate on record as per the Supreme Court rules. So how do they know? So what they do not want from you, is to assess your academic and curricular knowledge. They want to know how you can implement the Supreme Court rules to the ease of the registry and the court and to your clients. They do not want to know how much you know IPC, how much you know CRPC or CPC or Constitution. They want to know how you are able to apply a situation as per the Supreme Court rules for how you are able to present the case before the Supreme Court. And this they want to know in the first point itself. That's why this question of assessing on the basis of your answer sheet. If I am asking you to solve one question paper and come. So mere lectures, remembering sections or remembering articles, remembering case laws, they are very important. They are 100% the basic requirement. However, how are you able to present the first point that is required? For example, an examiner wants an important point from you. If you give the first point as required by him in your first answer sheet itself, then he will be interested and he would his battle readiness, his alertness towards your answers and your capacity will go on reducing. So what you must concentrate is make the examiner assume that you are a fit candidate and your keys and your approach is what is required of us AO1. So this is what you have to do. For that, you have to master the art of giving the best key available to a question every time, and this is what I will be telling in your lectures. And I would like to give certain general tips. See, drafting legal leading cases and Supreme Court practice and procedure. These are based on current affairs situations, and current affairs means what the Supreme Court is recently seized on. For example, you might see the constitutional the debate going on in Supreme Court regarding death penalty, regarding the issue of hung assemblies and the floor test, and so on. Review petition, how it is maintainable against a second review petition, or the floor test, why it is required. For example, the Arunachal Pradesh just got over, it was a constitutional bench hearing that was going on. Now the Uttarakhand State Assembly's Supreme Court might be seized of the matter very soon. And the same you see the death penalty and the relaxation of death penalty to death penalty convicts. The necessity of a second review petition in case of persons facing a hanging sentence. All these things are discussed in the Supreme Court in the recent times. So questions you can expect. And the another thing regarding the practice requirements, learned Honorable Justice Thakur had recently made a very landmark judgment on the practice of advocates. That is, persons, non-practicing and practicing advocates. Persons need to be enrolled in a particular bar association and examination papers. They are not academic evaluation, but practical application-based evaluation. Therefore, you must be able to cut across the technicalities and make your presence of mind be evident in your answer sheet. And it should be on the basis of applying principles of jurisprudence, and those principles should be your understanding of the principles and the presentation and the priority of the presentation. These are all very important. And see, priority of the presentation of jurisprudential principles. This is the first thing they would like to see. Whether you are able to apply jurisprudential principles, constitutional principles in your day-to-day practice. And second, the most important thing in solving an advocate on record examination paper is that whether you are abreast of the recent developments in Supreme Court. For example, in 2013, if anyone would write the exam, then almost all the 2014, if anyone would have written the exam, it is almost as if almost all the questions will be based on the recent amendment to the Supreme Court rules. So they will be likely to test you on whether you have properly understood the impact of the amendment of the Supreme Court rules and the present practice situations in the Supreme Court. And for if you are going to write now, then what is the recent developments? See the Supreme Court Constitutional Bench hearing on Arunachal Pradesh Assembly. Then Supreme Court order on practice and practicing advocates and non-practicing advocates. And Supreme Court order on promotion in SC/ST posts. Whether a direction could be made to the state government on the need for promotion on the need for SC/ST candidates being filled up in promotion post. Like that, Supreme Court has made several landmark judgments every year, and those judgments and how you have read them, how you appreciated them, these are all will be evaluated in your answer sheet and your question papers also. So your current appreciation of the practice trends of Supreme Court and the recent landmark judgments of Supreme Court, and you are able to how you are able to correlate them with the leading cases and how you are able to use them in the drafting and the practice and procedure. Your application to the trends in Supreme Court This will be a great way of increasing your marks. For example, for 55 and your application of the recent trends in Supreme Court, your understanding of recent trends in Supreme Court practice and leading cases and judgments, if you are able to show them, then definitely to that extent another 10 marks will be increased. And handwriting and then priority of presentation. I think that is the first thing. You must be able to give the first point first. If you are writing your first point in the second page or third page of your answer, then your marks out of 20 will be 8 or 10. If you are writing in the first place and you are writing in a proper conceptual manner, then your marks will be 16 or 14, 70% or 80%. Therefore, you will be passing the paper. So that is what you must practice. This exam comes with the basic minimum standard. That is, you must have practiced at least for 1 year in the Supreme Court, and you must be aware of the Supreme Court rules and the leading cases. There is no getting away from this. So, when you are going to write this exam, the basic understanding is you are not just gobbled up few books and few rules and come up. No, that's not like that. You must have had a minimum basic practice. You must have almost practiced in all the different lines: transfer jurisdiction, original jurisdiction, appellate jurisdiction, then writ. All these sites you must have practiced, contempt. Then you are having a fair understanding, and that fair understanding of Supreme Court practice and procedure is what is tested in the core papers. Therefore, the fair understanding is coming with your ability to make the presentation of the best points first, and your understanding of the current principles in Supreme Court. These two things you are able to combine and show it to the examiner. Even though your answer sheet has only 1 page of answers to a big question, if this point is conveyed, I think you will be the first mark. You will get the first mark. So this is what I will be trying to tell by way of the 4 lectures I will be uploading in YouTube. And this is a practice and test upload. This will be done. And you can expect the next 4 lectures in a week's time. Thank you. Best of luck.